Mr. Chair, you have a quorum. All right, first up, Delegate Rush. What you got?
Thank you, Mr. Chairman, members of the committee. We have House Bill 366. And what this bill does is...
Delegate, I think this is probably in a pretty good condition. This bill, if it reports, it needs to go to Finance. And my understanding is that this bill is simply going to give the state police and law enforcement information they need to know in order to find out who has had their rights restored. So if they've got a weapon in their car and it's Saturday, they're not thrown in jail over the weekend. Anybody, is that basically what it does?
Yes, Mr. Chairman, I do think the state police would have a comment, though.
They love it, right?
They would like to have it in a different posture.
Oh, different posture, okay.
Mr. Chairman, Keenan Hook, the State Police. We do love the bill. We believe we need fingerprints in order to implement it. The criminal history database that the restoration of rights information would go on is a fingerprint-only record. Every other record on it is fingerprint-based. In order to ensure that we apply the right restoration to the right person, we just want fingerprints. We think we can do that with about 7 words inserted into the bill.
Is that going to change the fiscal effect of the bill?
The department would not need any additional fingerprint examiner or anything like that to do it. So from our standpoint, no, sir, it would not.
Y'all don't need any more resources.
No, we do not.
So we're not going to see something from the department.
Well, Mr. Chair, is the department the one that's going to be taking the fingerprints? I mean, the fiscal impact, I think, is going to be on the local sheriff's departments that have to.
Mr. Chairman, Senator Deeds, the Virginia law allows a local agency to charge up to $10 for taking a set of fingerprints. So I believe that the cost for that would ultimately be borne by the petitioner, which I believe is what Delegate Rush is concerned about.
All right, Delegate, what are your thoughts about this?
Well, Mr. Chairman, I certainly respect the state police and the job they do. Currently, they get this information. There's 2 systems. So the system for the background checks at gun shows, which we've all supported, and then this system that the road deputies, police officers, and state troopers use when they pull someone over or they're investigating that person. So my feeling is they didn't need it here. I didn't want to have someone who had went through the process to get their rights restored to have an additional cost on them. But I did, Mr. Chairman, if I may add one more, I did put a delayed enactment clause on it until July 2019 so that that the state police and I could work maybe over the summer. But I do think we need to get this in because it's very important. And I have a story, but I don't want to bore the committee.
Well, Mr. Chair.
All right, any questions, first of all, just about the policy of providing this information? All right, Senator Deeds.
Well, could I, Mr. Chair, if I could suggest that a better approach might be for us to amend the statute that allows for restoration of rights or for the gun rights and require fingerprinting as part of the petition process, and then the cost can be added, and maybe send that amendment, ask the governor for that amendment on the bill, or ask him to send the bill down, because this is going to cause additional fiscal impact on the people that have to take the fingerprints. I think that might be a better approach than trying to amend this bill in committee.
Do you feel that they need fingerprints?
It's not my feeling that they do because these guys already have the information. We're allowing, once these rights are restored, and not to bore the committee, but you have your rights restored, then you have another step you must do to get your Second Amendment's rights restored. And then so my feeling, and that information is then given to the state police for the background checks at gun shows. So they don't need it there. His position is that system is based on that.
Mr. Chair, Senator Peterson, I would just simply, if the administration thinks there needs to be an extra step, they're going to have a voice in this process, which we're not at there yet. So I just go ahead and move the report.
All right, it's been moved, and we'll certainly listen to state police and work with you as this moves its way forward. There's a motion properly seconded to report the bill. Clerk will open the roll. And we refer to finance.
And we'll take good care of it.
Thank you, Mr. Chairman. Thank you, Mr. Chairman.
We love our kindred spirits, right? Yes. All right, just checking. All right, next up, Delegate Ranson. She's got a. What bill is that?
Mr. Chairman, Delegate Ranson has 1491. It is identical to Senator McDougal's 888, which was reported from Senate Courts 13-0 and passed the Senate 40-0.
Mr. Chairman, this was the right-of-way to put the power line underneath the Rappahannock River instead of over top, and I move to report.
All right, motion has been made and seconded to report the bill. Any discussion? Anybody here in favor, in opposition to the bill? Clerk will open the roll. All right, Delegate Ward. Good to have you with us.
Good afternoon, Mr. Chair, members of the committee.
274?
Yes,
All right.
274. You may recognize this bill. This committee passed it unanimously last year, passed the Senate 40-0. What this bill would do is grant court service units the discretion to divert up to 3 truancy offenses throughout the student's entire public education. Currently, that restriction is of 1 diversion of truancy over the course of the student's education, but it fails to take into account the unique circumstances facing certain youth at home, at school, and during certain levels of their education. For example, if this truancy occurs during the elementary school years, 1st, 2nd, 3rd grade, that truancy is more of a parental issue. High school, middle school would be due to a host of different unique situations at home or bullying in school. So that's the reason why we are looking at 1 truancy diversion during 3 major stages of a student's public education. As you can see, this bill is truly focused on the child.
Right, so if you have a truancy diversion as an elementary school student, it doesn't prevent one in high school.
Correct.
Okay. Anybody have any questions of the patron? Anybody in the audience wish to speak in favor of or in opposition to the bill?
Move to report, sir.
All right, it's been moved and seconded that this bill be reported. Clerk will open the roll. Well, congratulations and thank you very much. Next, we've got Delegate Price. Or do you have another?
Thank you. Thank you.
All right. $10.33.
Yes.
All right.
Mr. Chairman and members of the committee, HB 1033 attempts to create a more expeditious process for first responders and public safety officials who have been exposed to bodily fluids while on duty to get said fluids tested in order to learn sooner about possible exposure to life-threatening viruses. HB 1033 would allow a magistrate or the General District Court to issue a testing order of bodily fluids for a public safety official. We had an example in Hampton where an officer was exposed on a Friday evening, and current code provides that she had to wait to go before the General District Court to get the order. She was given a wide range of medications to cover the possible diseases, but could not get it tested until later. This bill would allow for her and the thousands of public safety officials like her to go through a magistrate to get an order in a more timely manner so that the blood could be tested and they would know if there were any concerns with the exposure. The bill that you have before you is a product of collaboration between the Hampton City Attorney's Office, the Hampton Police Department, the Virginia Department of Health, the Department of Forensic Science, and OES at the Supreme Court.
All right. Delegate, we, and I appreciate the explanation, we try to work these bills over, take a look at them in advance, and we have a group that's fairly diverse in background and experience. And I just want to call on our counsel, Mr. Benjamin, to maybe talk to members of the committee for a minute about some of the concerns that the working group that looked at this bill had. And after he talks about it will certainly give you an opportunity to address some of these concerns.
Okay, and I also have with me Brandy Law with the city, an attorney with the city of Hampton.
Well, I tell you what, why don't we wait just a minute and let your witness step up and address the bill, and then we'll turn to Mr. Benjamin. Okay? Welcome.
Hi, good afternoon. I'm Brandy Law. I'm an attorney for the city of Hampton. I don't really have anything to add. Delegate Price did a really good job of explaining. We've been working on this bill for a couple of years and believed that we had addressed all of the concerns that were out there. So I'm just anxious to hear what those concerns are.
Okay, well, thank you. Anybody else wish to speak in favor of the bill? Senator Saslaw.
Thank you, Mr. Chair. Brian Porter on behalf of the Virginia Association of Commonwealth Attorneys. We do support the bill.
All right.
Thank you.
Anybody else? Anybody here in opposition to the bill? Steve, why don't you address some of the issues?
Yes, sir, Mr. Chairman. And as you have noted, Mr. Chairman, we all recognize the good faith and good intentions of the patron and the supporters in bringing a bill like this and their desire to address a very real problem. And so it's in that spirit that we worked through the bill and noted a number of problems in no particular order. For example, although the bill expands the jurisdiction to magistrates to issue these orders and provides for an appeal from the magistrate to the circuit court. The problem is that under the code, the circuit courts don't have jurisdiction to hear appeals from magistrates. And so to effect that process, another section would need to be amended to add additional jurisdiction to the circuit courts for that purpose. There's also no process currently in the code for an appeal from a magistrate to a circuit court, and so the bill would need to create such a process. A third concern was that if magistrates order a person to submit to a draw of blood and to an analysis of the blood, and they refuse, there's no remedy for noncompliance. A person cannot be held, for example, in contempt of court for not following a magistrate's order. And so you have a magistrate issuing an order, but no remedy for noncompliance there. The determination that is to be made by a magistrate or even by a district court judge is whether the exposure to the particular virus would be such that under the then current guidelines of the Centers for Disease Control and Prevention, it would be an exposure which could transmit the virus. The problem there is how a magistrate, especially, or a district court judge, is supposed to determine what the then current guidelines of CDC are and whether under those guidelines the virus may be transmitted by that particular exposure. Finally, we had some angst over potential Fourth Amendment issues. A blood draw is a search within the meaning of the Fourth Amendment, and although there are circumstances where the Fourth Amendment permits blood draws, we're most familiar in those situations where there being probable cause that the draw of the blood will reveal evidence of a crime. And here, the only probable cause determination being made by a magistrate or a district court judge is that, again, under then existing guidelines, there may have been an exposure to a bodily fluid that may have transmitted a virus. There is not, for example, a requirement that the person from whom you are drawing the blood, there's no requirement that there be probable cause that that person have a virus, which we would be concerned about. And again, these are all what you might consider technical issues. They are not meant, Mr. Chairman, to detract from the good faith and good efforts and intentions of the patron, but as you know, it's our duty to the committee to analyze it in that manner.
Thank you. Senator Stewart.
Mr. Chairman, I likewise I like the intent of the bill and what we're trying to do, and I think that it's a good bill. But I do have great concern over giving this amount of authority to a magistrate. This is a search. There's no question about it. And I think that the power to authorize this should rest with the court and not a magistrate. So that's my 2 cents. If staff could help us, I would move that we eliminate the provisions for the magistrate to be able to authorize this. If anybody wants to second it.
Mr. Chair.
Sir, well, is there a second to the motion?
Well,
I'll second it.
okay.
All right, there's a motion properly seconded
Mr. Chair, make a comment?
on the motion,
Yes.
okay?
And on line 102, it says if the general district court or the magistrate determines. So is it just a matter of striking the words "or the magistrate," or do you think a GDC judge can't do it?
Mr. Chairman,
Senator Stewart.
I'm just uncomfortable with magistrates.
So we're just striking the words magistrate.
Well, let's ask counsel, is any further surgery necessary to this bill in order to accomplish Senator Stewart's amendment? We'll,
Mr. Chair, if I can ask Senator Stewart a question. Your purpose then is that have the petition to the general district court revealed in circuit.
Well, that's actually the current, I'm sorry, Mr. Chairman, that's actually the current statute. So the change we were trying to make was to add the magistrate. So if it's not the will of the committee, then.
not much purpose in the bill?
Right, yeah,
Okay.
it doesn't do much to change current code.
Okay. All right. You want to, so it's not a friendly amendment, so
Right.
do you want to withdraw that or want to move forward with it? Senator Stewart?
Mr. Chairman, I will withdraw the amendment, but I can't support the bill as it is.
All right.
Mr. Chairman,
All right, the bill,
yeah,
and I tell you, Senator Edwards, you want to be heard now, or you want to let the city attorney say a couple of words?
yeah, go ahead, do that first.
All right.
Hi, good afternoon again. Some of the concerns that were expressed by council are already in the existing law. So how does the magistrate or the general district court determine the then current standards? It's already in the law that they have to determine those standards. Typically, the health department, so a representative from the health department would come and testify. As to the Fourth Amendment issues, I would say that's also in the then current law. And then the magistrates already have the ability to order blood draws for DUIs. So that's kind of why we thought that they would be in a good position in this case. And I know it is a search warrant.
Right.
Versus a civil matter, but they're kind of in a position where they already kind of do similar things. For the appeal piece from the magistrate to the circuit court, that was requested by the House Courts of Justice Subcommittee. So we would originally had it as an appeal to General District Court, and that is something we would consider doing, moving back to, but the House Courts of Justice Committee did not like that process.
Mr. Chairman, I would
Senator Edwards.
move to get it back to something more logical, magistrate to general district court, rather than jumping over general district court.
Well, that's what the bill is.
Yeah.
Yeah, she didn't want to do that.
Oh,
All right.
no, but the magistrate could issue the search warrant, but that's what you want, right? And but then the original bill was to appeal that to the general district court if somebody wanted to, rather than the circuit court. I'd make that motion. I mean, that's the logical thing to do.
You're making, you like the bill?
I have another question, though. That's more of kind of a fundamental question. I don't want to mess with the bill, but is there such a thing as a search warrant under the Fourth Amendment for evidence not involving a crime? Is there a crime here? Where's the crime? I just want to know. I don't want to mess with your bill, but I'm not sure the current law is even constitutional.
Well,
Yeah.
we're not going to, I mean, it sounds like we're either going to make that worse or we're not going to fix that here.
I don't want to mess with it, but.
Well,
And I did want to add that we did add into our bill language that wasn't in the existing bill,
Right.
existing statute that said that this could not be used in any criminal process.
Mr. Chair, I actually want to sort of throw a life preserver here. I actually like that language where you say that the evidence that's recovered can't be used in a criminal investigation, which is kind of the whole point.
Mr. Chairman, it sounds good, but the problem is, although it can't be used as evidence in a criminal prosecution, if you discovered drugs in that person's blood, that could be the subject of a second search warrant to seize the blood for the purpose of a criminal prosecution. So it's not I recognize that the patron tried to protect the criminal interest, but it doesn't get there.
I respectfully disagree because the testing is limited to it only tests for HIV and hepatitis A and B. So I'm not sure the testing that we're doing would discover drugs, although I'm certainly not a medical professional.
Mr. Chairman, responding, if then the test disclosed that the individual was infected with the HIV virus and the police knew that that person had had relations with somebody else, then they could then on that basis get a search warrant for a second draw and then use it as a prosecution for malicious exposure of a virus. I'm sorry, but that's how it works.
All right. I hear a lot of people who like what you're trying to do. Senator Stewart.
Mr. Chairman, I like what the delegate's trying to do as well, but I don't think we're going to accomplish it in this meeting or, in fact, in this year. I think that if you work on this and others are willing to help you, perhaps our council can help as well. But based on that, I'd move the bill be carried over for the year.
Is there a second? It's been moved and seconded to carry the bill over for the year. Clerk will open the roll. All right.
Ayes 9, no 6.
Thank you.
Thank you. And we'd be more than happy to work with you. So thank you very much. Delegate Herring. 1055.
Yes, 1055. And, Mr. Chair, I didn't know if there were amendments that were suggested by the Supreme Court. It will actually makes the bill a little better, I think.
Okay. Who's got those line amendments? Charles?
Yep. Mr. Chairman, these are technical amendments. On line 16, after during the, we're going to strike the remainder of the line and insert judge's term. And then on line 19, after section 19.2, 298.01, we're going to insert the Virginia Criminal Sentencing Commission shall provide such information to the Supreme Court by November 1.
Thank you, Mr. Chair. And I hate to say exhibits, but I have a handout that would sort of help and understand why I'm bringing this bill.
Yeah. First of all, let's is there a motion on the amendments? It's been moved and seconded to adopt the amendments. All in favor signify by saying aye. All opposed. The amendments are adopted, and we'd be happy to distribute those handouts. Why don't you, in the meantime,
Yes.
tell us a little bit about what you're trying to do.
Right. So this is, I've tried several years, and hopefully exhibit will explain what I'm seeing and what we've seen a trend. Actually, it was a group of mothers that came to me regarding sentencing and judges, and we know that the sentencing guidelines are not mandatory, they're discretionary, but I've seen documents where there is not a reason put down for the departure of the guideline. And that is a problem. I think that someone who's sentenced needs to know why a judge or, increases from the guidelines or goes below. But I am also concerned about finality of judgments. So this bill will allow a petition for writ of mandamus to have an explanation for the departure from the guidelines. And it also seems like it's also a good evaluative tool for us when we are interviewing judges to see, as part of whether there's a departure, but also whether they are following the requirements of Virginia law.
Senator Norman.
Explain to me, with your amendment, does the writ of mandamus remain in the bill?
Yes.
Mr. Chairman.
Senator Norman.
Explain to me how you envision that writ of mandamus working.
That's someone who is sentenced will have the opportunity to file a
Procedurally,
petition.
Mr. Chairman.
Senator Norman.
Procedurally, how do you envision that working?
If you're asking, I would assume they can go beyond the 21-day appeal time. So procedurally, after the sentence has been imposed, if there is not a written explanation or even if I know some forms just have a box check, that the individual who's sentenced can request that be done.
Mr. Chairman.
Senator Norman.
The finality on the 21 days usually runs from, say we're in the circuit court where the judge has entered a sentencing order. And the judge has not appropriately complied with the statute. So after 21 days, they could still file a writ of mandamus. And would that in any way, in your perspective, impact the finality of the judge's decision? And if so, is it just a sentence or does it go even further?
Right, so the intent of the bill is not to go further. It does not, in my understanding, it does not affect the finality of the sentencing, and that's not the intent. The intent is to make sure our judges are complying. And what I handed you, you'll see that some judges are at 9.9% in failure to write down reasons for the departure. I mean, there's 12%, 11%, and I think that it just goes to the integrity of our system.
So Delegate, and this isn't your bill, but, I mean, your bill tries to get them to comply more frequently. If I depart up or down, doesn't matter, and I just write bad facts, either way. I depart up and write bad facts. I depart down, I write bad facts. Have I complied? Just on every case.
I think, honestly, I mean,
yes.
Yes, the answer would be yes, you've complied. But there are judges, though, who write a little bit more.
And
that's an issue of
good.
training.
But I worry that what you're asking for is, drivel. I mean, you're going to get, these judges who don't comply are going to give you useless information, and nothing you're doing will change that. I worry.
Mr. Chairman.
I can understand.
Senator
Chairman.
McDougall, Senator Norman.
I probably have less concern about us having access to the information, so I think that could be valuable when we're making determination about judges. I have grave concerns about a writ of mandamus, and so I would not be able to support this with the writ of mandamus.
Mr. Chairman,
Senator Norman.
Mr. Chairman.
Mr. Chairman, I like the substantive provisions other than the writ of mandamus, and I would make a motion that we delete the language pertaining to the writ of mandamus.
All right, it's been moved and seconded to remove the writ of mandamus from the bill. You accept that as a friendly amendment?
I do.
Or relatively friendly?
Yes, I
All
do.
right.
I accept.
It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? That amendment is made.
Mr. Chairman.
Senator Edwards.
Yeah, having litigated this fairly recently in the Supreme Court of Virginia, I'm pretty familiar with how all this works.
Thank you.
And I think if you want to pass it by for a few minutes, I could come up with some amendment that might be helpful. Ken may not want it, but if you could pass it by for a few minutes, I could chat with the.
I think it's the chair. I'm fine with passing it, but if he wants to help out,
What, till next year?
Oh, no, sir.
I think we're really trying to move on these bills. If
Okay.
you want to pass it by temporarily, and you and Senator Edwards can step aside and work on that for the next 15 or 20 minutes, we'll gladly come back to you.
All right.
And the order that we've got here, just so if anybody wants to go and come back. We've got Murphy, Watts, Guzman, Brewer, and Hugo. So we'd be more than happy to call as your bills are approaching. So Delegate Murphy, you're next.
Oh, thank you. I could hardly wait. Thank you, Mr. Chairman. This is House Bill 661, called First Offense Assault and Battery Against a Family or Household Member, Enhanced Penalty. What this bill is on the second conviction of a misdemeanor assault and battery charge against a household member, a previous deferral and dismissal of a first offense of assault and battery will be treated as a prior conviction for the purpose of determining then whether a person is eligible for the enhanced Class 6 felony penalties for stalking or assault and battery against family or household member.
All right.
I mean, I can tell you about studies, I can tell you about how many women are the victims of homicide and assault and battery, but I think you know those
Sure.
statistics.
I wonder if there are people who would like to speak in favor of your bill?
Yes, sir.
Mr. Chairman,
Senator McDougal.
I'll also make the comment that in the Senate, we determined to pass one bill that had a Woodrum impact. I would not anticipate that we would pass two House bills that had Woodrum impacts. So as we're reflecting on these, it might be a good idea for this committee to make a determination of what they think is the most important Woodrum impact bill to go forward.
All right.
Well, I might add that this had a budget amendment, and it was designated by the committee on the House side as one of the bills that would be funded.
Y'all had a lot of money.
We are very rich. This is a bill, actually, that you saw, I think it was 2 years ago. It was a bill put in by Delegate Todd Gilbert. I was a co-patron at that time, and we brought it back because it's a bill that deserves to be passed.
All right. Well, thank you. Mr. Doucette.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys. I was a child. I was brought up with the proverb of first time, shame on you, second time, shame on me for allowing it a second time. And this allows it for a third time, and actually a fourth time before we make it a felony offense. This bill makes it a third time. And so with that, the Virginia Association of Commonwealth Attorneys supports the bill.
All right. Is this your favorite House bill with a Woodrum impact? Or do you wish to withhold comment on that?
I'm trying to think of the other ones that we have.
Like maybe felony homicide?
Mr. Chairman.
If I had to pick, Mr. Chairman, I would have, I'm sorry, Delegate Murphy, but I'd have to pick the felony homicide.
All right.
Well,
it
it's
just
my
informs our
first choice
judgment.
to
It
be
doesn't
passed.
guide our judgment.
Could we go
Mr.
from
Chairman,
that?
but isn't
Senator Howell.
it the Finance Committee that decides which ones?
It's just, as I said, it just informs our collective judgment. Just interesting, since we have Mr. Doucette here, might as well take advantage of the opportunity to ask him, so.
I'd be more than willing to
I
cover
don't
finance
think-
as well, Mr. Chairman.
That's great. I
But,
look forward to
Mr.
seeing
Chairman,
you. Senator Howell.
I don't think we should deprive Delegate Murphy the opportunity to visit us in Finance.
I think that would be delightful. I know she's wondering what she's going to be doing for the rest of session, so we'll maybe give her another committee or two to visit. We'd love to hear from the other folks who'd like to speak in favor of your bill, Delegate.
Mr. Chairman, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We would kindly urge that this be the one to pass through. We support this bill philosophically in having the belief that there must be a proportional response to violations that's strong enough to deter behavior and leaves room for stronger sanctions in the future if necessary.
All right, thank you. Yes, ma'am.
Thank you, Mr. Chair. Sushila Varghese from Virginia Poverty Law Center. We support this bill for the reasons expressed before. There's a deep connection between subsequent convictions and homicide, as we all know.
Right.
So I think this would save lives.
Mr.
Thank
Chairman,
you.
before she leaves, do you also support a petty larceny taken under advisement being used for
That's
a
out of
grand
my,
larceny?
that's beyond my pay grade, so I'm not going to respond to that.
Mr. Chairman, is that any different than this? you have a person who's given an
I'm
opportunity?
a domestic violence attorney,
Okay.
Mr. Chair, and that's what I'm focused on, so thank you for your questioning.
And we appreciate your advocacy. All right. And my first impression of this bill is it was a really good bill, one that addresses an important issue, and it was entirely favorable. I think we did talk a little bit about some of a policy issue that was a little counterintuitive, and whether this was potentially going to serve as a disincentive for people to take advantage of the first offender status. Steve, you have any thoughts about that?
That's correct, Mr. Chairman. The current statute dealing with domestic assault, just as with first offense petty larceny or first offense possession of controlled substances, provide express jurisdiction for courts to take those matters under advisement, put the defendants upon terms and conditions so that they get treatment, generally requiring volunteer community service as an additional sanction, a year's probation, and then dismiss. And part of the rationale for that is to reward somebody, to encourage them to get treatment, and to encourage that by offering dismissal. The domestic assault statute, in recognition of the material concerns that each of the witnesses has expressed, has been amended over the years so that it has already deviated from other first offender statutes. Currently, and I think this amendment just came about last year, Mr. Chairman, if somebody wishes to take advantage of a first offense domestic assault, then number one, they have to agree that the facts are sufficient for a conviction. They are then placed upon probation not for 6 months or 12 months, but for 2 years, during which they have got to be of good behavior, and in addition, they have to receive whatever anger management or treatment that the court orders. In these surrounding jurisdictions, there is a 24-week program that is used, and that's encouraged, and it's a great program. But there's an additional kick. If you are violated during those 2 years, first you give up your right to appeal if the judge finds the facts are sufficient, and you're on probation now for 2 years. But during those 2 years, if you reoffend, not only with an instance of domestic assault, but if you reoffend or don't comply with probation in any sense, then you are found guilty and you have already given up your right to appeal. That is, you have given up your right to forever have the case heard by a jury, to ever contest your guilt. It's a substantial waiver of certain constitutional rights. Each time that we add additional sanctions or amend this, we increase the risk of the current statute being challenged as unconstitutional on its face. We also run here's a policy consideration. We further discourage people from taking advantage of this. It simply becomes too onerous. And people may well decide that it's better to just go ahead and take a first offense conviction, not have to be on probation for 2 years, not have to go through 24 weeks of anger management and healthy relationship counseling, and not give up any rights should things go awry. And so perhaps it's counterintuitive, but amendments such as these work against those who are concerned about domestic abusers, the first time it occurs, receiving necessary counseling.
Okay, Mr. Chair.
A final point would be that we've never done this before. We have never provided for a dismissal to be counted as a conviction for purpose of enhancing a penalty.
Senator McDougall, then Senator Peake.
Mr. Chairman, 2 things that really struck me. One is traditionally when we've done these, a lot of times when we have the third offense, it's in a time frame. There's a look back period. But the thing that probably had a greater question about was right now, if somebody took a deferral and dismissal today, and in the future, under the law, that it could not be used against them as another offense, is it ex post facto by us looking back and doing these retroactively? So for this law to even be constitutional, when you have to, it only be prospective. That's correct. And that, Mr. Chairman, Mr. Benjamin, that's not in this. So right now, this is unconstitutional as written.
All right. Yeah, Senator
That was a
Peake.
yes?
Okay, and Mr. Chairman, I think a question for Mr. Benjamin, and just want to make sure I'm correct, under the way the law is now, I mean, if we do this, it counts for 20 years. Is that under 52?
Forever.
It says, if it occurs within a period of 20 years, it's a class 6. 20 years.
Where do you get that?
Is that what this will do?
I don't think it's limited to 20 years. What line is?
Mr. Chairman.
I'm looking at 57.2.
I am.
For that's B, the last sentence in B. In any combination which occurred within a period of 20 years.
That's correct, for 20 years.
So were you getting one taken under, Mr. Chairman?
Sir, B.
You have one taken under advisement. 19 years go by, completely different situation. You could have been a spouse, girlfriend, then a child or a grandchild, and it automatically becomes a class 6 felony. Is that correct? if
That
you
is
pass
correct.
this?
Another nuance about domestic assault is if you live together with someone for a week,
Yeah, or 6 months.
a week, a month, and then you break up, boyfriend, girlfriend, you just break up, and then 11 months
Too
later,
long.
there's
Way
an
too
assault, that's domestic
20
assault.
years. 20 years.
All right. Yes, ma'am.
Mr. Chairman, I believe the way that this reads is it's for the purpose of determining whether a person is eligible for enhanced Class 6 felony penalties. I think that when they're offered this dismissal and deferral, it is in the hope that they will get help and that this kind of behavior will not continue. Many of these people recommit these crimes in a very short period of time. When they're convicted 2 times of domestic abuse, it's violent domestic abuse. When they are convicted twice, what we are asking is that you can go back and see if this is a continuing pattern. And in this case, they were already in front of a judge. They were granted an opportunity to change their ways by being given a dismissal and a, whatever you call it, deferral. And then they've proven now that they aren't able to change their ways or not willing. And so we're saying before he has to get to the 4th time, which then is in fact a felony, well, if you're dismissing, if you're not going to allow the first incident, which was dismissed and deferred, to be counted, he beats her 2 more times, then he's got the 4th time then becomes the point at which you're going to do something about it. So we're asking you to look at this from the victim's perspective and give them a chance.
All right, Senator Stewart, then we'll.
Mr. Chairman, I supported this in the past.
Yes.
But the law has changed since then. And I had forgotten about that until Mr. Benjamin just reminded me. And I believe it was last year that we now inserted in the law a requirement that you waive any right to appeal. And to me, that's a big deal, because now we're saying if you want to participate in a first offender program, we want you to, and you try to get help, but you can't appeal if you foul up. You've given up any right. And so to me, it's incredibly unfair to now use that against someone for sentencing enhancement, particularly when you talk about making it a felony. And listen, I don't condone these people at all. I had to deal with them when I was a Commonwealth's attorney and got just as frustrated as Mr. Doucette does. But it is just inherently unfair to use that as a conviction when you have waived your right to an appeal. And I think that's the difference from the last time we looked at this bill.
Well, Mr. Chairman, I think it's inherently unfair that the victim has to go through it as many times as they do.
Let's hear from Mr. Doucette. Mike, maybe offer some illumination on some of the points. Before he forgets them, let him get them off his chest, and then we'll come back.
Mr. Chairman, what I'd like to do is address the concern about there being some disincentive, if this bill passes, on taking a deferred dismissal. And there's a very powerful incentive that is not being mentioned in this particular bill, but it is out there, and it's always out there, and that's the federal law that bars one from possessing a firearm with a misdemeanor domestic violence conviction. Under Virginia law, because we don't take away a right to possess a firearm for someone with a misdemeanor DV conviction, we have no restoration provision. So anyone who's convicted of a misdemeanor DV conviction one time is barred for life from ever possessing a firearm, because we do not have a mechanism for restoring that particular right. So that is a very, very powerful incentive for someone to take the deferred dismissal and not go through that. And obviously, we're assuming that somebody if they're not taking it because they are worried that they're going to run afoul, is that they're planning on beating their girlfriend or their wife a couple more times, and people don't go that way.
Senator Howell.
Thank you, Mr. Chairman. This originally was my legislation way, way back, and Delegate Murphy has exactly described what our intentions were. And I am frankly sitting here getting increasingly upset with the cavalier attitude that seems to be taking place here with women's lives. There have been comments about we're only going to get one bill out of finance, $50,000 for each of those bills. And now we're talking about trying to prevent serial abusers from doing that. And I'm just telling you, it sounds real bad to me.
Senator Norman.
Mr. Chairman, I love Senator Howell like a sister. And I have a modest amount to do with Senate Finance, and you have not heard a peep out of me about bills that will or will not come out of Senate Finance.
All right. Now,
I should add one thing, because the emotional impact of this bill is evident to everyone when we talk about women being violently beaten. I know that the committee gets that, but the committee should also understand that assault occurs when you raise your fist to someone. It does not require that you make any physical contact. And we see those cases throughout the juvenile and domestic violence, in the JNDR courts, domestic relations courts. And those are the people who need counseling and intervention at a very early point. So it's not just beating a woman. And so that emotional impact needs to be understood in the context of, if you raise your fist in anger, then that is the crime of assault.
Mr. Chairman, can I ask a question about this? Assault and battery, does that also just mean raising your fist?
Well, battery's a touching.
Well,
right.
It does say that.
It said, yeah, it does say assault and battery.
Assault and battery.
Yeah. Okay.
all right. The bill is before us.
Mr. Chair.
Yes, it is.
Right. Senator Peterson.
I'd move to report.
And re-refer to finance?
Sure.
I'll second it.
It's been moved and seconded. Clerk will open the roll. All right. Thank you very much. Delegate Herring, you ready?
And I thank Senator Edwards for as the amendment that he suggested.
1055.
The amendment would have a basis for appeal for abuse of discretion. I just know the reality is that wouldn't work. The amendment that he suggested would allow an appeal for an abuse of discretion, and I don't think that will fly on my side of the chamber.
So you want a vote on the bill as it stands?
Right. I think there was an amendment. Take off the mandate.
Yeah, I think we've already voted on the amendment.
Okay, yes.
All right, is there a motion on the bill? What are you moving? To report or pass the bill by, carry it over? All right. Motion is to report. Clerk will open the roll.
Thank you.
Ayes 11, noes 4.
Right. Thank you so much.
We took Aunt Mandamus
She
off.
said she didn't think it would fly on her side, is what she said.
No, with the one that Edwards
Oh, the one-
suggested.
Oh, okay, I'm sorry.
All right, next, we do have Delegate Watts, although you've got, what, 4 bills? 3 bills? Would you consider allowing Delegates Guzman and Brewer to go, or does that defeat the purpose of having gotten here earlier than they? You can. I will let you go ahead. And I'm sorry to put you on that position. I don't know about that. Delegate Guzman. You owe Delegate Watts a debt of gratitude.
Thank you, Delegate Watts. Thank you, Mr. Chairman. Thank you, Delegate Watts.
It's good to see you.
Good to see you.
976.
Yes, members of the committee, House Bill 976 talks about compensation for wrongful incarceration. This transition grant already exists and it doesn't have any fiscal impact. What the bill is asking is just to add a time frame of 30 days. The organization that issues the check is the Executive Secretary of the Supreme Court, and she is okay with the timeline and came and testified in courts of justice in the House, and it came with full support from courts of justice and full support from the House as well.
I think it's a fine bill, and it's consistent with the policy we took with respect to, I think, death benefits for law enforcement officers to give them in advance when we know that the compensation is coming. So a motion has been made to report and seconded. Any discussion, anybody here in favor or in opposition? Clerk will open the roll.
Wow. Thank you
All
so
right.
much.
Yes, indeed.
Thank you.
Congratulations.
Thank you.
I hope this is your first bill.
It is.
All right, we're going to try and keep it on track for you. All right, Delegate Brewer, can you be just as fast?
Yes.
All right.
Mr. Chairman, brevity is my art form. I'm coming for you today with House Bill 525. Don't forgive me for being from the House.
Regrettably, if it reports, it has to go to the Finance Committee as well.
Oh, wonderful.
525.
Just a little bit about what this bill does is there's actually a carve out in the code section when it is in regard to carnal knowledge. Currently, law enforcement officers, clergy that even enter a detention facility, pretty much everybody else who enters a detention facility, juvenile probation officers, everybody is guilty of a Class 6 felony if they carnally know someone under their direct authority, with the exception of a carve out for bail bondsman, which is a Class 1 misdemeanor. Unfortunately, I wish I could say this. I brought this to you because I love to be in front of courts, but this was ripped out of the headlines locally, and we will have a bail bondsman that will be able to practice again when he gets out of prison if we don't work on elevating this. So.
All right. Anybody have any questions of the patron? Sarah Norman.
I move to report the bill.
All right, motion's been made and seconded to report and re-refer. Clerk, anybody here wish to speak? All right.
Mr. Chairman, I don't want to stop the motion, but if I understand, it does 2 separate things. 1, prevents you from getting a license, and 2, creating a new Class 6 felony?
Correct. And it was funded in the House budget, passed for appropriations unanimously, and also currently as it sits,
Just strike the board.
Bail bondsmen are an arm of the court, and so therefore, if it's elevated to felony, they would not be able to renew a license.
Mr. Chairman.
Senator McDougall.
So it's only by the felony status that they're prohibited, but you could prohibit somebody from a misdemeanor of a certain type from practicing as a bail bondsman.
Correct.
Okay. All right. Clerk will open the roll. All right. Congratulations.
Thank you, Mr. Chairman.
You bet. See, Delegate Watts, that wasn't so bad, was it? All right. Take your pick. 303?
I'll go in alphabet in numerical order. So the first one is 303.
303, as you recall, a couple of years ago, we did an extensive look at the problem of perk kits not being properly analyzed. And so that in that reform and these particular legislation which says that after law enforcement agency has received a perk kit, it shall submit within 60 days. There's a slight problem if the evidence needs to go to another law enforcement agency. This closes that problem by adding another condition.
You aware of anybody expressing any opposition to this?
No.
Anybody on the committee have any concerns about this? Anyone in the audience wish to speak for or in opposition to it?
Mr. Chairman?
I think y'all like this.
Thank you, Mr. Chairman. I'm Linda Jackson, the Department Director for the Department of Forensic Science. This is an agency bill. We are obviously in support, and it is just to handle so that the correct law enforcement agency can make the decision whether or when to submit it to us, and we appreciate Delegate Watts for carrying this for us.
Senator McDougall.
Mr. Chairman, so if I'm, just to make sure I understand correctly, the law enforcement agency that collects it submits it to the law enforcement agency during the investigation, that once that agency receives it, they have 60 days from that time. We're not giving them more time than that 60 days to submit it.
That would be correct.
Okay.
That's the way it reads. Mm-hmm.
All right. Is there a motion?
Mr. Chairman?
Senator McDougall.
Is it, I'm just trying to think. So the maximum amount of time that this could take to be tested would be
19
days, is that technically?
Conceivably, but I honestly do not think that that's the issue, that when you realize that this needs to move to another law enforcement agency, or they realize that there's an issue here, I don't see a potential for delay. I think it is, in fact, an appropriate recognition of it now before the agency that knows that the investigation is important.
Okay. All right, the bill's before us. It's been moved and seconded. The bill be reported. Clerk will open the roll. All right, next, 3 or 4.
The next one has a little bit of a history, and this is HB 304.
We love multi-jurisdictional grand juries in here.
That's what I have come to learn. Therefore, I would regard it as a friendly amendment. If you were to strike from line 10 through line 65 and change the title so that it's only referring to 59.1200, which is the Consumer Protection Act, taking out any reference to the multi-jurisdictional grand jury.
Mr. Chairman, you're not wanting to repeal that part, you just don't want it in your bill.
I just don't want it in the bill. Yes, absolutely. No, I'm not working both sides on that issue. No, this is just to take it out of the bill so that all the bill will do is add the.
I got you. So all you want to do is add exploitation of mentally incapacitated persons to the coverage of the Consumer Protection Act.
That's correct. And this is definitely a step forward, given the nature of the predatory behavior that I'm trying to address.
So what do you
Chairman,
think, Senator
I'll
Stewart?
move that amendment.
Is there a second? It's been moved and seconded. All in favor signify by saying aye. Aye. All right, does that amendment do what we think it did, Council?
And you've done the title amendment as well.
Yes, Mr. Chairman.
All right.
We're just putting those under the Consumer
Okay.
Protection Act.
And again, speaking briefly, if I need to
Well,
the
let's see whether
remainder.
you need to.
All right.
Anybody have any questions or concerns as it stands? Is there a motion?
I'll move to report the bill. Second.
All right, it's been moved and seconded to report. Anybody wish to speak in favor of or in opposition? Clerk will open the roll. All in favor of reporting signify by saying aye. Well, never mind.
Stanley wants you to explain.
I got it.
Ayes 14,
I
noes
got
1.
All right, and your third bill
Is
is
1516.
$15.16. And
And this is on the previous discussion that I was here to learn and be enlightened by. This is one on the House Court side that we call one of our icebox bills. We always wait until the end. We usually have about 30 to 40 bills that have a fiscal impact statement. We wait for appropriations to tell us how much money we have, because it used to be when we sent them up to appropriations, they had no one on House side that had any criminal background because they were too busy.
Let me just maybe try and short circuit this and get to the heart of the matter. What this tries to do is ratchet up the penalty for prostitution-related offenses committed by adults in connection with minors.
That would be correct.
And I think that counsel, and it deals with residing in or visiting a bawdy house. And I think that we had identified a couple of things that might address a couple of concerns, and maybe Steve will report these, and you let us know if you like them.
I will respond.
All right. And the intent issue?
Yes, Mr. Chairman, focusing on line 215, we were concerned that it would not be the patron's intent that somebody be punished for a felony, even in situations where they didn't know that a minor was present or being used in these circumstances. And so if we're correct, what we would suggest is that on line 215, we add in front of the word violates, the word intentionally violates this section, and then after the word where, add the words he knows that.
All right. Everybody have that? So, the thrust of these amendments is to avoid making a felon of somebody who, without knowing, visits a bawdy house without knowing that there's a minor present. You okay with that?
Yes. Mhm.
Okay. Is there a motion to adopt that amendment? You need to speak out loud.
So moved.
All right, is there a second? It's been moved and seconded. All in favor signify by saying aye. All opposed? That amendment's adopted. Those amendments are adopted. All right, the bill is before us. Anybody wish to speak in favor? Yeah, Senator Peterson.
I got some questions. This is talking about making people registered sex offenders, correct?
Yes, it is. If I can now give you just a tad of background.
Sure.
Every other offense dealing with prostitution is a Class 3 felony. Every other offense is a Class 3 felony. This pickup, moving it from a Class 1 misdemeanor to a Class 1 felony, is going after, as we have tried to go after in any number of ways, a number of legislators, the problem of sex trafficking of minors. And so basically what this is going after is now going after, I'm going to say, the marketplace, where there's a market for and being used, and when there's no extra penalty or concern for someone who's using that minor, this is what it's going after. It's a Class 1 felony compared to every place else where you look through the code, it's a Class 3 felony. So this is where I feel it is proportional. And it addresses the issue that you've got to dry up the use of these minors.
Any other questions?
Yeah, I have I actually went and looked up these statutes in the code, and one is keeping a bawdy place. One is taking somebody to a bawdy place, and I'm looking up 349 right now. Maybe someone can tell me what it is.
And 349 is 100 years old. I've been educated on this. 100 years ago, the language was almost the same, except it talked about whether the vehicle
Using
was
vehicles.
horse-drawn or motorized. But there are vehicles certainly outside the gates of some military installations. It's very handy to pull up a van, and we have dealt with those issues.
Right. Senator Peterson.
Okay, so I guess my question is, and, you know, these are all already criminal offenses, so I mean.
Misdemeanors.
Are they misdemeanors right now?
Yes, they're class 1 misdemeanors. If you look to the next code section, I think it spells out that these three, 47, 48, and 49, are class 1 misdemeanors. I think it's the next or the next one after it.
So, just looking at 349, and I'm just looking at it, shall be unlawful for any owner or chauffeur of any vehicle with knowledge or reason to believe the same is to be used for such purpose, to use the same or allow the same to be used for the purpose of prostitution or unlawful sexual intercourse. So if one of my teenagers takes one of my cars out of the driveway and meets a group of friends and one of them is underage and sexual relations take place in a way that violates the law, does that mean I'm now in violation of 18.2-349 and you're going to have me here under an RSO order next year? I mean, what?
The issue is whether you reasonably believed it would be to have sex with someone who underage. Keep in mind that we do have in the code that sex with a 14 or 13-year-old is blanket. It's a felony. I believe that's, again, a class 3 or this is a class 3 felony. And so then we allow a 3-year age spread where it is.
Okay, but give me one moment, if I might, Mr. Chair.
Senator Peterson.
And Vivian, I don't mean to cut you off, but
No.
there's a reason why these are misdemeanors and not felonies, because they're written in more general, I don't know who this is trying to call me, but I cannot speak to them right now. The reason why these are written more generally and have more open-ended language, owning a bawdy house, allowing someone to use a vehicle, is because, frankly, it's a lesser standard of culpability. And you're now going to sweep them up and treat them as if they're the neighborhood pimp who's putting people out there, 16-year-olds, when in some cases they may be, frankly, unreasonable in allowing their teenagers to use the car or allowing their property to be leased by some shady people. Maybe somebody leases a commercial building and they set up a massage parlor and there's prostitution going on and the landlord's looking the other way. Okay, that's not great, okay? And there's reasons why that ought to be illegal, but making that the same as, again, you know, a pimp who's consciously putting girls out on the street and collecting money, it's a little bit different standard of culpability. So I'm not, again, I saw the train flying down the tracks and I just happened to look up these laws and be careful what we're doing here, folks.
And I do understand that standard of culpability, which is why I was particularly emphasizing that all the things that you mentioned are class 3 felonies.
Well, I just thought you said they were misdemeanors.
No, the things that you mentioned about the pimp getting money for using the girls, those are underage minors. That's a class 3 felony. And so moving those that are helping this activity, moving it from just a misdemeanor to a class 1 felony, I think is in line, again, always underscoring that it is a minor that's involved.
All right, well, tell you what, and I don't want to jam up this discussion again. I make the mistake sometimes of actually reading this legislation.
I do too.
All right, well, I'll shut up at this point, but I think I've expressed the concerns I've had, and I'll just leave it at that.
All right, Sarah McDougal. All right, motion's been made and seconded to report and re-refer the bill to the Committee on Finance. Clerk will open the roll.
Thank you very much.
Yes, indeed. Thank you.
I didn't think that 3, I don't know, 3, that's terrible. I'll never get 3 out. Thank you so
All right,
much.
you have another? We can.
No, actually, I don't. I'll put one.
Might be able to. All right, Delegate Hugo. This is an oldie but a goodie.
Mr. Chairman,
Senator McDougal.
just, I think we have heard this a lot, and I moved to put the accommodation language we had in last year's substitute into this bill.
All right, this is House Bill 1469, the felony homicide opioid bill. Delegate, I know that you probably aren't enthralled with the notion of the accommodation provision going in this. However, I doubt it will come as a surprise to you that the motion's been made.
Always respectful of the committee's will.
Do you want to make your pitch first, or do you mind?
I've always learned blessed be the brief, so.
Well, we can make it really brief.
Go ahead.
There's Senator McDougal's motion is to add the accommodation provision that has been added, I think, for the last 4 years in this committee. Is there a second to that motion? Motion's been made and seconded. Anybody wish to speak to that amendment? Yes, sir.
Not to the amendment, sorry about that.
I'm sorry?
Not to the amendment, thank you.
Okay. All in favor of the amendment signify by saying aye. Aye. All opposed? All right, the amendment has been made.
Move to report.
Well, let's let those who wish to speak in favor of or in opposition to the bill step up.
Mr. Chair, my name is Mark Birnbaum. I'm a prosecutor in Northern Virginia in the Attorney General's office. I prosecute a number of opioid death cases that arise in the jurisdictions up there. This bill tries to deal with an issue that arose in response to an appellate case, Woodard. There, the individual sold drugs in a parking lot. The victim used them at a different time and place. She subsequently died. The court overturned the conviction, saying that it was not a death in the prosecution of the felony. The difficult spot we're in right now is, given the realities of drug distribution and drug use, we can prosecute drug users who redistribute to a friend because the friend dies at the same location of the distribution. But we can't prosecute the dealers who distribute at a different location and different time and place. So this bill gets us to where we need to be with respect to dealers, and those are really the ones we want to target. So we appreciate Delegate Hugo carrying the bill.
All right, thank you very much. Mr. Doucette.
Mr. Chairman, Mike Doucette, Executive Director of the Commonwealth Attorneys Association. We support the bill as introduced. We support the bill as amended. We're in favor of the bill.
All right, thank you.
Mr. Chairman, so Chris Costa with the county, Fairfax County, and the Board of Supervisors supports the bill. I'm not familiar with the amendment, but I think I know what it means, and I think they probably, well, at any rate, that's what they've supported as introduced.
Okay, thank you.
Mr. Chairman, like I said, y'all have been very gracious with this bill over many number of years, and I appreciate y'all hearing it. I think they stated the case well. I could go but I'd just be repeating, what they said. So I appreciate y'all taking the time
Tim,
to review this.
I mean, it is an important bill, and I regret that we've been unable to get together on this over the past 4 years. I hope that this year we can. My part of the state, your part of the state, it is a really significant, serious problem. There's no silver bullet, but I would hope that we're going to be able to find a way to bridge the gap that separates the House and the Senate this year. So is there a motion on the bill?
Mr. Chairman.
I'm sorry. Hang on one second. Steve.
One comment I wanted to make to the committee. Obviously, we can't understate the seriousness of the opiate epidemic and the lives lost. That said, a fundamental policy in Virginia that has driven our jurisprudence forever is that a person is not held responsible in this state for the criminal conduct of another person. And the best known example of that is, I think it's called dram shop laws. What that means is that if a bartender commits the offense of over-serving a patron until they are just falling down drunk, and knowing that that person's going to get into a car and drive, and then that person does that, drives, although they're completely inebriated, and then kills somebody else, because of Virginia's longstanding policy of not holding somebody responsible for the criminal act of another, there is no liability or punishment, criminal punishment, for the bartender who has overserved a patron who then kills somebody. And this would be the first time that we have moved from that policy. A second consideration is that if somebody distributes drugs that then at a different location causes a person's death, that the distributor can still be prosecuted, of course, for distribution of the controlled substance. If it caused somebody's death or contributed in any way, then that's a factor to be considered at sentencing. First offense for drug distribution carries up to 40 years. Second or subsequent offenses carry up to life. And so that's a point to determine whether it's a necessary bill in context of this deviating from settled Virginia policy.
Mr. Chairman, just 30 seconds.
Well, I think,
yes, sir.
Mr. Benjamin is doing his duty.
Absolutely, well done,
And
as always.
trying to make sure that we are duly informed and educated and haven't forgotten the lecture that he gave us last year on the same subject, or the year before, or the year before that. We're duly reminded. There is a motion properly seconded to report the bill. The clerk will open the roll and re-refer to finance as amended.
Thank the chairman for the time. Thank the committee.
Thank you.
Good man.
With that, we're through our bills and the committee will rise.